Yes, you go first.
I was dealing with the steps that the authority hadn't taken.
Yes, we have decided that we will not, certainly now, and probably not today, deal with the further evidence and the issues relevant to disposal.
In which I will stick to 20 minutes.
Okay, off you go.
Yes, so I was dealing with the steps that the authority, the council, didn't take, and where the judge wasn't entitled to take the view that they'd taken all the steps they could. As a preliminary to that point, I do observe that Mr Beasley didn't give any evidence at all about what the procurement strategy was. He didn't give any evidence about what the homelessness strategy was, and he didn't give any evidence about as we saw, the Part 7 policy had a strategy about dealing with acquiring properties. And we have no evidence about what steps have been taken now or for many years in the past to deal with what, on the respondent's own case, is a chronic shortage of accommodation which is suitable for someone in the appellant's position. And in deciding whether the authority's done everything they can, that we suggest is highly relevant in itself, because only the authority knows, by their own lights, as it were, that as a manager of housing stock and as housing authority, only they know what the options are, or only they're best placed to do that. And if they haven't done that work, it's very difficult then for the appellant to say, well, to be put in a position where they're required to suggest things. The duty under Section 193 is a duty for them to fulfil, and it's not for the appellant to suggest particular avenues. That said, the evidence before the judge was, as I said, going to Mr Beasley's evidence, broadly to the effect that they wait for a property to become available, in the sense that it becomes available in their existing stock, however that's described. They then decide how to allocate it. In that sense, the appellant was considered for all of those properties. But what they didn't do anything to achieve was to secure accommodation outside that particular method of accommodation becoming available. We've dealt with out-of-borough placements, and Ms Steinhardt, who appeared below, put this on the basis that the authority hadn't gone to the open market. She talked of tens of thousands of properties, and although maybe that she didn't expressly talk about out-of-borough placements, it certainly didn't exclude that. But leaving that point aside, we suggest there are at least 5 ways that the duty could have been fulfilled that haven't been considered by the authority. One is to rent in the open market, whether in Croydon or somewhere else. Mr Beasley's evidence was to the effect that they were sourcing properties in the open market, but we've got no idea what that involves. Other than that one reference in the statement, we don't have any evidence of where they searched, who they searched, what criteria they applied, and where they looked. That's far, far below what's necessary to show that they're doing all that's possible, still less, all that's reasonably possible. And of course, in deciding whether or not to rent in the open market, they have to consider the full range of their powers to provide subsidies for rent or help with paying rent. The second point is adapting this property. The evidence was that Mr Beasley, who's not an expert, went round and took the view that it probably wasn't something that he thought was feasible. It was going to be pursued, and there has been no further, I won't say what's happened, but there was no evidence of adaptations ever having been seriously pursued until the point when Mr Beasley went round, and then a further step was suggested which might have helped, but certainly hadn't been taken, which was to have an occupational therapist go around and to see what adaptations were possible. Thirdly, and it's a variation of that point, that there's no consideration given to adapting other properties in the council's stock and then arranging allocations in such a way that that is then provided to the appellant. It's something I discussed a little bit earlier. I won't go into details of that. Fourthly, we have no idea how much of the authority's own stock or pool of properties, whether you talk about the authority's own held stock or nomination rights, how much of that is at the disposal of the authority for Part 7 purposes as opposed to Part 6 purposes. And so, whether or not, theoretically, we're in the territory of saying, oh, you've got to use all of your Part 6 stock for Part 7, we simply don't know what the authority has done in this respect, because the authority hasn't told us. And again, it's not possible for the council to satisfy the court that it's done everything it can without giving that kind of detail. And then fifthly, there is the option of buying a property, again, whether in Croydon or elsewhere. And notably, although Mr Beasley said that the borough was in a projected deficit of £67 million at that time, he didn't say that the council wouldn't be able to afford a capital expense of this kind, which would be dealt with differently on the council's accounts. And so nothing.
I mean, it would presumably be, it would be a capital asset, so it wouldn't be
exactly
dead expenditure, and indeed a rent would be paid.
Yes.
Yeah.
And so there's the practicalities of buying simply weren't addressed, and indeed Mr Beasley appears to simply have ruled that out on the basis that he thought it would cost too much, but it's clear from his statement that he hadn't explored it because he didn't really know what any particular property would cost. So there were at least those options, and we set out further detail about that in paragraph 67 of our skeleton. I won't take you to. So that's the point about all they reasonably could. The third point is about taking into account resources. We've dealt with this in our skeleton at paragraph 66. I'm not going to take up time going through that. You've got my general points about whether resources can be taken into account. But the point I would want to make is that if you're against me on the point that resources can't be taken into account at all, there is, we would suggest, if resources are to be taken into account, then it's got to be on a principled basis that respects what we say is the fundamental divide between the court being asked to enforce a duty and the court being asked to adjudicate on what in effect is a discretion which is only challengeable on Wednesbury grounds. And we would suggest that if resources are to be taken into account at all, then one way of respecting that divide would be to ensure that the test is pitched at an appropriately high level of impossibility or something like it, and it's perhaps not necessary for these purposes to delve into the precise ingredients of that. That's the first point. The second point is that the court has to be satisfied that that standard is met as a matter of fact on the material before it, rather than in circumstances where it feels that it has to defer to the authority. Because once it starts doing that, then as a matter of practice, the duties that it's being asked to enforce turn into discretions. And thirdly, we would say that in approaching that exercise, the court has to apply an extremely exacting standard and require the council to provide precise detail about why it is that they're in the difficulties they say they are, and for the reasons I suggested before lunch, there's nothing remotely unfair about asking an authority to do that, because they ought to know anyway, if they're taking their duty seriously. So that's about resort. The remaining point I'd make on resources is we refer to the way in which the judge dealt with the DOM decision and taking budgetary decisions as a given. We don't add to what we say there, except to say that a further reason why that's wrong.
What's the reference in your skeleton?
It's in our skeleton, it's paragraph 66. And a further reason why we say that that doesn't stand in the way of mandatory relief here, is that that's looking to the future. Dom was all about whether a past decision would preclude a particular kind of challenge, but what we're asking about here is, well, what's possible in the future to meet the duty. So I'll now move on to the virus point, and the submission there is that the judge was wrong to accept the proposition that purchasing, building, leasing or adapting a property specifically to accommodate the claimant wasn't open to the defendant.
Can we see exactly what he said about that?
It's paragraph 62.
Yep.
And we see 4 lines down there. I accept Mr Rudgley's submission of purchasing. That was the point I was.
Yep.
And he reached that conclusion by reference to Begum. This is the point really that we can deal with.
Sorry, just I want to see exactly what he said.
Yes.
Begum's a slightly different point, isn't it?
Yes, it is. Begum, the thrust of the reasoning in Begum was you can only allocate accommodation once you have it, and until you have it, you can't allocate. Once you've got it, you have to allocate in accordance with Part 6, and therefore you can't escape the allocation scheme by going and earmarking a property.
But I understand that, but when one goes on to 81.6 and parts of what is said at 62, the impression I'm getting is that he is saying this: you buy it for Part 6 purposes. The question then is whether or not you depart from using it for Part 6 purposes and use it for Part 7 purposes. And he thinks that wouldn't have been right because it would have been unfair.
No, indeed, that's a separate point, which I'll come to if I may.
But that seems to be his reasoning rather than 62. I understand what you say about 62 being muddled, but I'm not sure whether it fed into his reasoning at 81.
Well, my lord, in which case perhaps I can deal with 62 briefly by saying that we say in effect that we step around that difficulty by saying that we aren't dealing with a Part 6 offer here at all. Part 7 is not constrained in the same way. So if the authority acquires a property, then it can dispose of it as it wishes in accordance with Part 7. And although the judge and the respondent both assert that there is a similar inhibition on departing from a Part 7 policy, that they don't identify any basis on which that is right as a proposition of law.
It's the fairness, isn't it?
Well, if I can just deal with this and then I'll come to the fairness in about 30 seconds.
So as a matter of law, they could buy a property, use it for Part 7.
Yes.
And whether you say that or whether you say they buy it for Part 6, there's nothing to stop them using it for Part 7.
Exactly.
As a matter of law, they could use it at the end of the day.
Yes, and nothing stands in their way because Part 7, or the Part 7 policy they have, doesn't prevent them from using it in that way. You saw that, and even if it did, it couldn't prevent them from fulfilling their statutory duty, and we rely on Begum and Justice Collins, where a very similar situation arose, where the authority in that case had a policy about using its stock for Part 7 purposes, or not using its stock for Part 7 purposes, and the policy couldn't prevent them from, or couldn't be an offence to a breach of Section 193. So that's the parts, the various point in very brief outline. We do want to stress a couple of things about that. It is that this is an important problem because it has very, very far-reaching consequences if right. Because very many authorities don't want to hold standing stock, and they do go and allocate property or earmark property, and they may have to for cases of extreme need. And so if this says they can't do it, then that would be a very serious impediment to them. Second point I want to make is that although we don't need to challenge Part 6, the Part 6 decision in Birmingham, we don't want it to be said that we agree with it. Broadly, there are 2 points. One is that allocation is a process, and so it can begin before you acquire property. And secondly, it really all depends on the policy. If your policy allows you to earmark, then in practice you can do that. And if your policy doesn't allow you to earmark...
This is all very rushed stuff. I've got lost.
I'm sorry, Lord. I won't deal with this point because I know time is pressing and I need to go on with the...
There are 2 questions. 3 questions. One, as a matter of law, could you acquire a new property and by a particular route use it for Part 7? You say yes. Either acquire it for Part 7 outright or acquire it for Part 6, and there's no reason to stop you switching it to Part 7. That's what you say. You say the judge got wrong in paragraph 62 for reasons I haven't yet understood, but I'll go back and read it. But the third question is whether or not that was the thing that he was saying when he got to a mandatory injunction. Was he saying, oh yes, that would have been a solution, but it's not lawfully allowed? Or is he saying it's not reasonable to require the authority to give preference within Part 7, buy it and give it to one, you'd have to do it for everybody, or is not fair to switch things from Part 6 to Part 7?
Yes.
That's what he says. In 6 he's dealing with, could she have had a Part 6 property? Not a virus point, could she have had a Part 6 property? She wasn't arguing for that, and he explains why it wouldn't have been fair. And then the question is, should she have got it as a Part 7 property? And he's saying, no, that wouldn't be fair either, because there are lots of others who would want Part 7 a property.
No, indeed. And that's what I was going to turn to.
And those are the 2 things that he actually says.
Well, I was going to turn to that point now.
Ah, right.
Which is that the broader submission he accepted, which was that it would unfairly prejudice the position of other applicants on the priority for Part 7.
Yeah.
And there are 2 strands to that reasoning. One is that there's a collision with the Part 7 scheme, which there isn't, because the Part 7 scheme doesn't actually say anything about that. But more importantly, he talks about fairness to other applicants and the inability of the court to weigh the claims of the multitude. And that, we say, misses the point of the exercise that the court is being asked to engage in. It's the point I've made before, that what we are dealing with here is enforcement of a duty rather than reviewing an allocative discretion. And in this case, since we are involved with the performance of a duty, the authority has no discretion whether or not to fulfil it, but it is inviting the court to refuse relief, in effect, because it may be in breach of its duty to many other people who it is entitled to consider when deciding how to perform its functions and whether to fulfil a duty to anybody. That, we say, is at the very least an unattractive proposition, because what it means is that it invites the court to refuse relief, not because, as in the Ahmed kind of case, where you're dealing with an allocation scheme, the court is refusing relief in order to assist the court in fulfilling its functions, but in a case where the authority is saying, well, because we fear we can't meet our duties to everybody, the court should deny relief to everybody as well. And we, the authority, should be left to decide which of the people we're in breach to we should fulfil our duty to. And that is an extreme proposition, and one we say which is contrary to established legal principle, and it would be an incorrect basis on which
I don't think that they're just saying that you shouldn't make a mandatory order in this case because we're also in breach to everybody. What they're really saying, as I understand it, is by making mandatory order in this case, you would exacerbate the breach experienced by other people because of the, we don't have the precise data, but because of the queue jumping effect, namely that you enforce in this case, but you exacerbate the position of other people.
But
It's not simply a question of that's the same level of unfairness.
Well, my lord, it's wrong to think of this in terms of a queue, because when you talk about queues, you are using the language on
my language, but you know what I mean, which is other people who may be in a similarly regrettable position, some of whom may be in a worse position,
but my lord,
and may have been waiting for longer.
But my lord, that does amount to a claim that it is for the authority and not the court to decide which of the people they are in breach to should get.
Your position would be, would have to be, and see the force of it. Well, those people too probably have such a claim.
Exactly.
Indeed, they have margin. If it isn't a matter of absolutes, they have a stronger claim. But certainly, on any view, they have the same claim. And if they choose to bring it, they will succeed.
Indeed,
and tough.
And there is nothing we suggest contrary to principle or unfair in saying that when a claim is brought before the court in those circumstances, the court should adjudicate on that claim, and that's simply a consequence of people enforcing their rights.
This is why I think it's where we were before lunch. You're saying it's a matter of law. You simply can't have differentiation between them because they're all people who have got over the hurdle of having the duty owed to them. And thereafter, they all have the duty. And it's irrational to say we'll enforce it or not enforce it for some and not for others because of the unfairness on the others. They're all in the same boat. And all 206 people on the waiting list under Part 7 are equally entitled to a mandatory injunction. There will be no circumstances in which you could refuse a mandatory injunction.
Well, the court, obviously, if matters, if there were several claims before the court, then the court can order its own affairs. And
I don't understand what that means.
Well, the court could order to decide which order to hear the cases in, and
doesn't matter. If they do it over a week, they'll all get a mandatory order, and the council has got to go out and buy 106 houses if there's no other option, or take 106 houses, whatever the number is, out of Part 6 or a combination. And you say, yes, because that's the law.
Well, certainly that is that is our starting point. But where it leads to, if one wants to temper it in a more pragmatic way, and I'm not inviting the court to do so, is that the court needs to be very, very careful indeed before it accepts these kind of arguments, that because there are lots of other cases, that it ought to stay at hand. Because
I don't know what you mean by it. Got to be very, very careful indeed.
Well,
your position is an absolute position.
Yes.
Well,
and I respect that. I think there's a lot to be said for it. But I don't quite understand what sort of halfway house you're arguing for.
It's not so much a halfway house, but what we have here is that there is absolutely no evidence before the court as to what the scale of this issue is.
Okay, well, don't repeat points. You're already over time.
But for all we know, that there are a handful of cases in which case it's not a serious problem. And if an authority is going to run this kind of point, but for all the unattractive reasons that you said, then it needs to be absolutely clear what the number of people are that it owes a duty to, what their circumstances are, what it's been doing in relation to them, because only then can the court begin to get involved in...
Do I understand it to be part of your... Although you put it in absolute terms, because that's in principle what it is, you accept there can be built into that, as part of the ordinary discretion of the court, not to make a mandatory order if it is satisfied that the delay is short, or will be short.
Yes, and the way that can be reconciled with principle is that a mandatory order is not necessary in order realistically to enforce the duty.
Well, it is, because you mean the duty exists on day one. Yes. It's a departure from principle, and maybe one you can defend on other grounds. It's a departure from principle to say, well, I'm not going to make a mandatory order because I'm pretty sure you'll do it by day 90.
Yes, but there's little difference between that and making a mandatory order for day 90. If you're
All right,
satisfied,
no, well,
yes.
but still making a mandatory order for day 90 is a departure from
No,
principle.
it is, but the court will always give time.
Well, all right,
And
but
that's-
the worry about that is once you've made that breach in the absolute position, where do you stop?
Well, there is a distinction we suggest between the court giving time and the exercise of the court's remedial power, because it's then imposing what it considers as a reasonable, practicable period to comply with the order, and a situation where the court licenses a prolonged breach.
Well, I think we're going to have to bring these submissions to an end.
Well, that was my last point, subject to what Ms Steinhardt has to say, which is, so that was my last point.
And we'll ask. Well, well done, Mr Westgate. Yes, Mr Rutledge.
Thank you, my lord. I handed up yesterday 2 additional materials, which is the excerpt from Volume 1 of the Weekly Law Reports, the case of ex parte Hendy, a PDF format.
I expect you did, but I haven't got it to hand.
We now can see it's a proper law report.
Yep, I have it. Yes.
And the second were 2 further pages from Judicial Remedies in Public Law.
By a certain well-known author. Yep.
Dealing with duty to perform specific acts. That, my lords, goes in at B3, tab 76, page 1202.
Okay, let's put it in now, otherwise we'll lose it. So of course we all have copies on our
And
shelves.
Hendy is bundle 1, tab 18.
Thank you very much.
My lords, the fundamental question underlying both appeals that the lords have heard this week is how can the courts reconcile the mandatory nature of the main housing duty owed to the homeless person with the fact that the local authority may have no accommodation immediately available to it with which to fulfil that duty. And my lord, from the local authority's perspective, there are 3 possible solutions. The first is to construe section 193 subsection 2 as requiring the local authority to perform the duty when it is reasonably practicable for it to do so, which is the case presented to the Lords on behalf of Birmingham City Council. The second possible solution is to accept the duty as an immediate duty, but to give suitability, sufficient elasticity to enable the local authority to discharge that duty in stages, starting, if necessary, with something that is just suitable, whilst the local authority searches for something better, which can be described as the Airways and Arley solution. The third solution, when all that fails, and where suitable accommodation cannot be sourced, is to ameliorate the hard edge of the main housing duty by reference to the discretionary nature of the relief being sought. In some cases, the court will grant relief compelling the local authority to perform its main housing duty. In other cases, it will not, as a matter of discretion. And it's on the exercise of that critically important discretion that the Croydon case comes before your lordships. The mere existence of that discretion is an important protection for the local authorities who, like the London Borough of Croydon, in my respectful submission, have made honest and honourable attempts to secure suitable accommodation for those owed the main duty, but are frustrated by an excess of demand over supply in their area. My Lord, it's a feature of this case, and one which perhaps distinguishes it from many of the other cases we've looked at, and as my Lord Justice Lewis has observed, that Croydon has, throughout the litigation, accepted that the main duty is owed to the applicant and that the accommodation which he occupies is unsuitable. Stood by that decision. How unsuitable it is.
It didn't have much choice, did it? Because a decision was made on review that it was unsuitable, which would only have been challengeable, which you had no right of appeal against.
It had the choice, my Lord, because it was seized of a request for review under section 2021F for the suitability of that accommodation. It could have decided that, notwithstanding the problem of the level access toilet facility on the first floor, the property was nonetheless suitable per se, or alternatively it could have decided that the property was suitable for the time being, but it chose not to.
Well, I'm sorry, it's my fault. I think I was wrongly treating the reviewing officer as someone separate from Croydon. Croydon, the reviewing officer had that choice.
Yes.
Once that choice had been made, you were stuck with it.
Oh yes, yes, I accept that. I didn't.
No, I know you didn't, but
Result
I just
from that.
it's easy to regard the reviewing officer as it were someone other than Croydon. But it's,
Yeah. No, I'm Lord.
Okay.
Of course not. And I'm not suggesting for a moment, no part of my case, that there has not been an extant duty, an unfulfilled duty, since 2015. But my submission is that, perhaps unusually in this area of law, Croydon has accepted that, and it's faced the problem head on. And as my lords have seen, the only issue before the Deputy Judge on ground one of the judicial review, the only issue was relief. There was no argument from Croydon as to whether the duty can be deferred or delayed or anything like that.
Can I just mention one small point while we're on that? Am I right in thinking he actually dismissed the claim?
I'm sorry, that it's...
That the judge actually dismissed the claim?
no, he allowed the claim on ground 3. There were 3 grounds. He dismissed ground 1, he dismissed ground 2, and he allowed the claim on ground 3.
So housing list.
Yes.
So with what we're concerned, he just dismissed it. The issues with which we're concerned.
I'm not sure
It
we
may
have-
not matter, but just suppose this claim had stood alone.
Then it would have been dismissed.
Well, is that right? Surely the right thing to do would have been, I know it wouldn't have got you anywhere because it didn't really matter, but formally the right thing to do would make a declaration of breach. The claim isn't a claim for mandatory relief. It is a claim for a decision that it is unlawful, followed by the appropriate relief.
My Lord,
This may not matter, but I'm a bit of a stickler.
no, can I deal with
Yes.
it? There was discussion before the Deputy Judge about whether the court should make a declaration that Croydon is and has been for that time in breach of the main housing duty. And the Deputy Judge was persuaded that that would not be a proper exercise of discretion.
Persuaded by you.
Yes, but because it would serve no purpose. It has never been in dispute in these proceedings that Croydon owed the duty. Mr Justice Chamberlain, I see recently in the Good Law Project case, made the point that it's no function of the court to rub the nose of the defendant in the admitted breach. It simply wouldn't have served any purpose.
Yes, it just strikes me as odd. I sort of see how you got there. It strikes me as odd to dismiss a claim where to dismiss a claim for which, if I may use private law language, for where the cause of action was that there was a breach.
But it was all. I'm so sorry.
The cause of action was that there was a breach. On the basis that there was a breach, but that you weren't going to do anything about it.
It wasn't an issue. There was no issue on breach.
No, well, okay, I see the point. But
The dispute was whether that breach should be enforced by way of a mandatory
Well,
order.
of course, that was a substantive dispute.
And there was-
I just don't know whether the right result of it was to dismiss the claim.
No.
But I think there are more important things to worry about in this case than that.
So, Lord, in my respectful submission, that's right.
Well, then let's move on.
But my Lord has the point that at no stage in this litigation has Croydon tried to dump the issue.
No.
And it has tried, and it assists
You have
tried
made
in
that
this
point.
court to get to the bottom and assist the court to deal with this, grapple with this fundamental issue of the clash between the hard-edged mandatory duty and what has so often been the elephant in the room, the lack of resources with which to deal with it.
The declaration point was dealt with outside the judgment, wasn't it? It's not to be found in the judgment. Is that to do with the afters?
Yes, I think so, yes.
I don't find it within the body of the judgment, is all I'm...
No, that was the afters, I think, yes. Can I just, before I set out, I'm conscious of the time, but I don't feel under pressure. I will pace myself and make sure that we get through it in good time, and Fran will have an opportunity to come back. I've set out in my, I've made reference in my skeleton to the case of ex parte Degnam, which was a suitability, we needn't turn it up just yet. It's at B1 tab 24, page 343, decision of this court under the 85 Act, before we had statutory reviews, simply as an illustration that, Lord, it would be no news to the Lords in this case, it's fairly straightforward, as to the standpoint of this court in reviewing the exercise of a discretion.
This isn't what this case is about. For 7 years, you've broken the duty. The
Yes.
question is, should we grant a remedy, and if not, why not?
But respectfully, yes, my Lord, that's how the Deputy Judge characterised it. He was encouraged in that respect by me, and it is a one-issue case. Was there an improper exercise of discretion? And what Degnam says is that, of course, there's deference must be paid to the judge, and this court should only interfere if it's satisfied that the exercise was vitiated by some legal error. And I'll, as reasons I'll develop, that's not the case. I want to set out my submissions, if I may, in 4 parts, which will broadly follow my skeleton argument. Part 1, I'd like to say a few things about the main housing duty. I will keep it short. I'm conscious that my Lords have looked at a lot of material over the last 3 days, and I will not go back to cases we've looked at unless there's a particular reason to do so. So part 1 will be the main housing duties, some general observations. Part 2 is our submissions on the test for mandatory relief in housing cases. Part 3 is time-specific mandatory orders. I can be fairly brief on that, but it's quite an important point for my clients. And of course, my clients are facing a claim for a time-specific mandatory order, initially 6 weeks, now 12. And part 4, I'd be putting before your Lordships Croydon's submissions on the single ground of appeal. And I'm grateful to the Lord for the indication that it does not require submissions from me today on the fresh evidence. Can I, before I do that, can I attempt to answer my Lord Justice Peter Jackson's question about the provenance of the Part 7 duty, the Part 7 policy that is shown. the short answer, Lord, is there's no statutory duty on the part of a local authority to hold a Part 7 allocation policy or policy concerning the way that it gives out accommodation. There's no statutory duty in the way that there is for Part 6. Part 6 imposes a mandatory duty on every local authority, regardless of whether they hold any stock, to have an allocation scheme. But my lord was shown briefly before the short adjournment the opening sections of the Homelessness Act 2002, which set out strategic duties on the part of local housing authorities to carry out periodic reviews and to have a strategy for dealing with homelessness. And it's usually under the umbrella of those statutory provisions, my lord, that the local authority will develop a Part 7 policy. And that's the position in Croydon and the document that Lords have been shown. It might be convenient, I don't want to take things out of order, but it might be convenient at this moment if we just have a look at the interplay between Part 7 and Part 6, because that featured in the discussions with my friend, and especially in relation to his point that if you've got a Part 6 stock, your duty is to use it for Part 7 purposes. And I just want to explain why that's wrong and to show, my lords, the interplay between the two sections. So, if we can turn, please, to Bundle 1, Tab 7. And this is the Part 7 of the 1996 Act, page 80. And then if we turn, we're familiar with it now, if we turn please to page 96, we see the current version of section 193. My lord, I'm respectfully very conscious of my lord's difficulty in being asked to decide a case on the wrong law. This is a general point, nothing's changed. So this point will stand for all purposes. But the Lords will see that the structure of section 193 is that subsection 2 imposes a duty where certain circumstances exist, and the only way that duty does not apply is if the local connection provisions are engaged. But there's the duty. Then subsection 3 tells us that duty continues until it ceases by virtue of the following provisions of this section. So section 193 is a complete scheme in that sense. It imposes the duty, and it also tells us when that duty comes to an end. And one circumstance in which it comes to an end, under subsection 6 little c, is where the applicant accepts a Part 6 offer.
And that is an offer of a secure tenancy pursuant to the powers granted by Part 6.
Or an introductory tenancy.
Or introductory tenancy.
Yes. Yes.
It's not a non-secure tenancy offered as Part 7.
No. I'll come to that. And then if we then look at page 76 of the same tab, we see section 166 capital A of the same Act, but this is in Part 6. Part 6 seems to have rather bizarre numbering because of the number of amendments, but this is a vitally important section, and it goes back to section 22 of the Housing Act 1985, and it's the reasonable preference And what my lords see, that subsection 1 imposes the duty to have a scheme. Subsection 2 is about choice-based lettings, and then subsection 3, as regards priorities, the scheme shall, subject to subsection 4, is about additional preference, be framed so as to secure that reasonable preference is given to, and then 5 groups. And the lords will see that the first group is people who are homeless within the meaning of Part 7, and B is people who are owed a duty by a local authority under specific sections, one of which is section 193 subsection 2. So there's a dovetailing between section 1936C and section 166A 3B, which caused Mr Justice Moses, as he was in the Anderson case, to say that's an indication that you might have to wait some time. I emphasise it's no part of my case that a local authority can accept a Part 7 duty, then sit back, put the applicant on the waiting list and say, well, take your turn. That's not the case. But I do share it to emphasise the point, and there are others, and I'll take the Lordship to a moment, that Parliament has understood that discharging, meeting the main housing duty is not always going to be easy. And there's another, perhaps
Can you
more
just help me on
way.
one small point? Why does it distinguish between people who are homeless within the meaning of Part 7 and people who are owed the main housing duty? People who are owed the main housing duty will be homeless, but of course they will also be in priority need.
But Lord,
But if you have to give reasonable preference to people who are owed the main housing duty, what's the point of that if you already have to give preference to people who are homeless without being owed the main housing duty?
the crisp answer is I don't know, despite having looked at it many times.
Right, okay.
But the best answer that I'm aware of is that little a is broad enough to cover what is sometimes known as the hidden homeless, those who don't present for assistance but are sleeping on a friend's sofa or rough sleeping or something like that.
Well,
So
we've got
they
enough
come
to worry
within-
about in this case
come
without
within
worrying
the
about
definition, but they haven't actually got the decision letter.
Where I'm struggling at the moment, I understand that the ways there's the duty arising, there's the period of time during which it has to be performed, which may involve, depending on circumstances, different provision at different time,
Yeah.
all of which must be suitable, and the ultimate discharge. The ultimate discharge would be a secure tenancy under Part 6 or an assured tenancy in the private sector. Broadly, I know there are other things, don't worry about the details. But this says that when you're dealing with Part 6, the ultimate discharge of a secure tenancy has got to be built into Part 6. But I thought Mr Westgate's argument is we're dealing with something different here.
Yeah.
We're dealing with the stages between duty arising and the ultimate discharge of the duty.
Yes.
And what he wants to do is take some of your, well, he wants to take one for his client of your Part 6
Take it out of the Part 6.
houses.
Yeah.
So it's not going to be allocated in accordance with
No.
Part 6. It won't be a secure tenancy. It'll be a non-secure tenancy.
It'd be a non-secure
license.
tenancy out of Part 6 stock.
Yeah.
Yeah, but my lord, the problem with that argument, one of the problems with that argument, if we go back to 166A at page 76, as I indicated, there are 5 groups. And if we just look to see how the other groups are defined, there's people occupying insanitary or overcrowded housing, or otherwise living in unsatisfactory housing conditions, people who need to move on medical or welfare grounds, including grounds relating to disability, and people have to move to a particular locality in the district where failure to meet that need would cause hardship. Some of the most serious cases that come to local authorities don't go via the homelessness route. They go straight into Part 6 because they're not homeless, but it doesn't mean they don't have housing need. They can have profound need.
I accept that. I understand that. And one recognises that. I just don't understand what the purpose of this submission is. You're not saying, or are you saying, I just don't know, are you telling me it's a matter of law? I thought you were going to show us something that as a matter of law meant you could not legally use Part 6
No.
for Part 7.
No, my Lord, so forgive me, that's
Right.
not my submission.
So what is the submission
You
then?
can't-
Why is this
well,
relevant?
My Lord, the submission is to meet the argument that you can dip into your Part 6 stock readily, or that Part 6 stock must be used first and foremost for Part 7 duties.
It doesn't
And all
stop
I'm
you.
saying is there's an order of priorities.
Well, my lord, I don't understand how that meets the argument you can dip into the Part 6 stock. If you do dip into Part 6 stock to satisfy Part 7 duties, then you're not allocating under the Part 6 scheme. So
No.
what?
No, and it says that if we look at subsection 14 at page 78, shall not allocate except in accordance with the allocation scheme.
Yes, that's right, but that means shall not do a Part 6 allocation.
I'll do a Part 6 allocation.
Yes, but the whole point about Mr Westgate is if his argument is good, it doesn't involve a Part 6 allocation.
No.
The only connection with Part 6 is the stock which
stock.
you have but there's no, that's just a pragmatic management earmarking. There's no statutory obligation to have something called Part 6 stock at any one time.
Lord, forgive me, it's my fault, I'm sorry. Of course, the local authority can use Part 6 as a means of discharging the Part 7 duty.
Yeah.
No. Do you mean Part 6 or Part 6 stock?
Yeah, it can use that.
No, which? Sorry.
I'm sorry, I'm building the submission. It can.
Well, all right, but I didn't understand the first step in the submission. You said, of course, they can use Part 6 to satisfy a Part 7 obligation, but I didn't understand whether you meant they can allocate under Part 6, which will obviously deal with the Part 7 obligation because it'll bring it to an end.
Yes.
Or did you mean they cannot allocate under Part 6, but take a property which they had internally regarded as available for Part 6 and use it to discharge a Part 7 obligation?
Yes, of course they can.
Yes, okay.
And I'll explain it. Of course they can. The reason for that is because the accommodation, whether it's for Part 6 or Part 7 purposes, will invariably come in through Part 2 of the 85 Act. And we'll look at that. When we see Section 32, that hopefully will make it clearer.
So you can use a house which is capable of being allocated into Part 6
Of course.
for the discharge or performance of a duty into Part 7. So how does this help you meet anything that Mr Westgate says? Because he says that's precisely what you should have done. You should say, look, there's a house there, don't use it for Part 6, give it to me into Part 7. That's what he says you should do.
Because it runs a coach and horses through both policies. The way local authorities operate is they have a Part 6 policy, Croydon has a Part 7 policy, they have an annual audit, they allocate properties to each policy scheme, and they
But that may suggest that the policies are wrong in law, because they artificially restrict your power to comply with your absolute duties under Part 7. You've got 10,000 properties, and to take an absurd example, you say 9,500 of those will all be used for under Part 6, and the remaining 500 be used for Part 7. And that's our policy. And if the court comes along, or someone comes along and says, that's doesn't make sense because you're restricting yourself from complying with your Part 7 obligation by having far too small an amount of stock necessary. It wouldn't be any answer to say, well, you're driving our coach and horses through our policies. The policies would then be wrong policies.
Well, with my respectful submission, that can't be right. The flaw, if I may respectfully say so, is the assumption that the only duty they will be faced with is a Part 7 duty. There's a whole range of duties that local authorities have to comply with. For example, Section 20 of the Children Act or the leaving care provisions.
But there may be lots of other problems we accept. But and I put that to Mr Westgate, but you can't have an independent Croydon where the law is your policy. You have to have the law of the land. And the law of the land is there are certain things that are duties. certain things are not duties, but are desirable. And what Mr Westgate is saying, I think, is that when you've got something like a house which could be used to meet an allocation scheme or which could be used to meet a duty, you should use it to meet the duty, or at least consider using it to meet the duty. And you seem to be saying there's some legal prohibition on that. And I don't understand what the legal prohibition is.
I'm not.
No,
Sorry if I'm not making
I didn't
myself
understand you to be saying that. I understood you to be saying there's no legal reason why you couldn't do so, but you should nevertheless not be expected to do so because it would be in breach of your policies.
Yes. And it would be unfair.
That's not a legal obligation.
It would be, no, there's no legal reason, technical legal reason why that can't be done. But local authorities are expected to have policies and to operate them fairly. And they do their best. They don't have enough property to fulfil their Part 6 requirements. They don't have enough to fulfil their Part 7 requirements. They do their best. They source the maximum number of properties and they allocate them between the two.
A lawyer would normally say the duty takes precedence over the...
Yes, but there are so many other calls on their houses. They have so many houses. They've got to meet a wide range of needs.
I think I speak for all of us in saying it may sometimes get lost in the back to and fro. We
No,
fully
it's-
understand the extraordinarily difficult position local authorities are in. But there is a complicated legal scheme, and our job is to see what the law requires
Yes, of course.
in these difficult circumstances. So please don't think, or those behind you think we don't understand. Not a job I think any of us would like to do. It's extremely complex and difficult. But still, we have got to say what the law requires.
Well, Lord, I understand that entirely. So, Lord,
Right.
I take
No need to lay it on thick because we do understand it.
No, I'm sorry if I was laying it on.
Yeah, I'm sure you weren't,
apologise. I think the Lord that's the point. I want to save time to go through the exercise, but I was going to, it's set out briefly in my skeleton, just to compare and contrast the modern day section 193 with the version that came in 1996, simply to show that in 1996 Parliament obviously felt that the local authorities could discharge their duty from their own resources, whereas increasingly through amendments brought about by the Homelessness Act, the Housing and Regeneration Act and the Localism Act, they've had to go out into the private sector. So to answer my Lord Justice Lewis's point, I hope I haven't misunderstood it. Permanent Part 6 accommodation isn't always necessarily the end game for Part 7. It can be a private rented
I did say that, and I said broadly, and I said don't get distracted about the detail. I can go and read the list, but it's broadly two things. The key is permanent, security of tenure under Part 6, or insured tenancy, whatever it's now called, in the private sector. It's the permanency rather than the...
Yes.
That's the key thing.
It is.
But don't get into the details.
No.
This case is not about showing whether or not we've
Lord,
is it assured short-hold tenancy or assured tenancy. They change the names every week.
Claudia, can I get on to the... I think that's all I wanted to say on my part 1 of my submission on the main duty. Can I proceed to part 2 of the test for mandatory relief?
Yes.
Lord, I set this out at paragraphs 17 to 26 of the skeleton. And I've started with a short excerpt from the Lord, from the Judicial Remedies in Public Law, Lord Justice Lewis is very familiar with, and I apologise for not including the earlier section.
That's the paragraph that's relevant, because the bit that you've quoted is when you've got general duties about providing schooling
Yeah.
and so on, and this is a specific duty owed to an individual, which is accepted, is enforceable.
Well, or is it? In my respectful submission, your lordship deals with, I hope I can put it in that way, with specific duties, and then goes on to deal with services.
Yeah.
So there may be a debate as to whether Part 7 assistance is a specific duty or a service. So I don't think I need to labour the
The
point.
key point is it's something that's owed to an individual and the individual can enforce. It's not like schooling. You're entitled to have a school.
Yeah. But that does lead me on to the Hendy case, which that text refers to. And Hendy was the one that I handed up earlier in the PDF.
Yes, thank you.
And that's Bundle 1, tab 18, 234. I'm still working off the Westlaw.
No, it was very nice of you to do it for
Um,
old people.
And I don't want to take too much time on this because Mr Straker took the court to it, although I think for a different purpose, and that is the argument about the nature of the duty itself. But this was a test case on the then newly introduced section 39 of the Land Compensation Act 1973, and if we look at the page, sorry my lord, I am working from my West.
Don't worry, we'll find
So
it.
sorry. We have the duties set out top of page 226.
Yeah.
And where the local authority makes a closing order, then subject to certain provisions which don't apply, a duty falls on the relevant local authority to, quote, secure that he will be provided with such other accommodation, close quote. And that means residential accommodation on reasonable terms. So there are some similarities between the language of that and 193. There were two issues in this case, as Lord Justice Scarman identifies at the beginning of his judgment. The application raises two questions of some importance. The first is whether there was a failure. The second is this a proper case for a court to make an order of mandamus? Lord Justice Stamp agrees with the Master of the Rolls on the first issue and then adds his views on mandamus, which Lords were read the other day. And then Lord Justice Scarman deals with this point. Again, I'm embarrassed because I don't have the PDF marked up.
It's the very...
Yeah, but it starts off, I hope it's marked, it's towards the end of his judgment.
just below the whole...
I think that any other construction, I am satisfied that mandamus ought not to issue in my judgment if a situation such as this, there is evidence that a local authority is doing all that honestly and honourably can to meet the statutory obligation, and its failure, if there be a failure to meet that obligation, arises really out of circumstances over which it has no control, then I would think it would be improper for the court to make an order of mandamus compelling it to do that which either it cannot do or can only do at the expense of other persons not before the court, who may have equal rights with the applicant, and some certainly have equal moral claims. For these reasons, I think the discretion ought not to make an order of mandamus. Those words are missing on mine, I apologise.
All the more reason to have the law report.
That's, in my submission, part of the ratio, but of course this is a decision on a different act. But in my respectful submission, this is highly persuasive of the general approach that the court should take when looking at a statute.
What was the nature of the impossibility relied on in that case?
Well, the evidence was from the town clerk, which was dealt with in the Master of the Rolls judgment. They simply couldn't source it quick enough, I think. What they did, the town clerk put in an affidavit. Yes, it's halfway down the judgment of the Master of Rolls. The town clerk stated that this is what the authority are prepared to do. The corporation are prepared to fulfil their duty by A, offering to the applicant as soon as practicable a tenancy of suitable residential accommodation on the terms normally offered by the corporation to prospective tenants, and B, lodging the application and his family in temporary accommodation until a suitable dwelling becomes available. And as my Lord Justice Lewis pointed out, the concern was that the tenant, due to the closing order, was losing Rent Act protected accommodation. And so the offer was of local authority accommodation. At that time, we didn't have secure tenancy, so there had been no statutory security attached with short-term temporary accommodation in the meantime. So I offer that up simply as a helpful example, I hope, of a case before this court on a statute which is not a million miles in terms of the wording, and the one we're concerned with is to the general approach. Lord, I'm conscious of the time and I want to make progress. I want to assist my lords as much as I can, but I don't want to deal with stuff that's set out in my skeleton.
No.
Thereby shortening the time that I have to deal with my friend's submissions. So, in a nutshell, we say, in paragraph 22 of my skeleton, sets out three propositions drawn from that case, relevant to the question of mandatory relief, a good faith attempt by the authority to discharge its duty, a failure resulting from circumstances over which the authority has no control, and a consideration of the competing rights of other persons not before the court. And we say that that third element chimes with what Baroness Hale said in the Ahmed case in the House of Lords, the Part 6 case, about weighing the claims of the multitude who are not before the court against the claims of the few who are. So again, it's looking at the broader picture. And I then go on in my skeleton to set out our position in relation to subsequent authorities, including Cardona, submitting that however one describes it, doing the impossible or honourable and honest endeavours, whatever, it pretty much amounts to the same thing, taking all reasonable steps. And I think ultimately that was the test that Mr Justice Linden applied in M, and Mrs Justice Steyn applied in Elkundi and the other conjoined cases. And that sums it up, because you wouldn't expect the local authority to have to take unreasonable steps. So in my respectful submission, in a case where respectfully it's crying out for a clear test, that's probably the right one to go for. I have to deal with Lord Hope and Baroness Hale in our ways, and I should do so. I was going to do that in the context of the judgment, but subject to that, my Lord, what we say in paragraph 26 of the skeleton, where we seek to pull...
The test is they're doing all they reasonably can.
Yeah, reasonable steps.
Well,
That's like then changing the duty back.
No, we're not suggesting the duty is reshaped in that way. This is for the purpose, we're only on the question of relief. Only on the question of relief. Have the local authorities satisfied the court that they have, and I'll come on to burden, have they satisfied the court that they've taken all reasonable steps? But that's not to say that the court can ignore other factors, least of all the aspirations and the legitimate interests of other applicants. That's the Hendy point. And we see that echoed in a number of the authorities. I mean, if I may respectfully say so, it's inconceivable that in a different area of law, a claimant can come to court asking for a mandatory order, which is one of the strongest orders that a court can make, a mandatory order requiring a public authority to perform a certain act within a certain time, without the court asking, inquiring, firstly, why do you need it? What are your circumstances? And secondly, what impact is this likely to have on third parties? My respectful submission, that's inconsiderate. Why should that be? Why should those considerations be excluded in this type of case?
As Parliament has said, if you're in a priority need and you've got nowhere to live, and it wasn't your fault, you should have it.
In
And
an
if you're
ideal,
not in that position, and you're somebody who's patiently waiting on the housing list, and you may be living with your parents or whatever, Parliament hasn't said that they should have it.
that's why I took the law to 166A3, A to E, because if the law, with respect, if the law's right, then you would expect a ranking. Parliament would say, don't just give a reasonable preference to the homeless, put them at the top, and then put the others below. It doesn't.
But that's security news. We're not talking about that.
No, I don't.
That's the whole point. Anyway, we've gone through that.
We've gone through that, my lord.
But you say that, have they taken all reasonable steps? Reasonable steps include why the applicant needs it, and it's not enough to say I need it because I'm homeless. You say that involves looking at the degree and nature of the breach. Here it was just the bathroom, and you said you've got to look at third parties, and it's not just other third parties who are homeless, it's third parties who have housing needs, and possibly third parties with wider calls on the council's services.
Lord, yes, we say that we say that these factors, these four factors, are likely to arise on any application for mandatory relief.
In effect, you're saying that no relevant factor can be excluded as a matter of law.
As a matter, that's right.
I mean, there may be reasons for giving more or less weight to certain factors, but all are potentially considerable by a court deciding a mandatory order.
Lord, yes. I mean, if we just go back and look, the Lord mentioned the question of a declaration. A declaration, the power to grant a declaration is statutory, Section 31 of the Senior Courts Act, and that lists criteria or factors the court must take into account when deciding whether to grant a declaration. One of them is all the circumstances of the case. So how can that be excluded? If you're asking a court to make a declaration that A is entitled to immediate accommodation, the court is bound by statute to look at all the circumstances. So we say...
Sorry, I thought you were saying about declaration. Is that so as regards mandatory relief?
No, it's not. In Section 31, the Lord Justice Lewis is going to correct me if I'm wrong about this, but my reading of Section 31, it's not in the bundle, I'm sorry.
It's here, but we need to look at it.
It applies to injunctions and declarations.
Well, perhaps a mandatory order is an injunction.
Well, that may be the case, but I would respectfully say that by analogy, if that's the case with the declaration.
Yes, I don't think probably ultimately Section 31 sits. Gives us the answer, but I was just wondering whether it's something we even had to look at. But you
No.
Yeah, okay.
I just made the point in response to the law question about it. So I would respectfully submit that where the court is being asked to make a mandatory order in a housing case, then the following are likely to be relevant considerations for the judge. The first is the seriousness of the breach. Where on the scale of breaches does this one lie?
Seriousness
measured
by what? Length, impact on the on the person, moral opprobrium. I mean, I don't quite know what seriousness means in this context.
But Lord, I didn't quite get to the end of my sentence. It's the
sorry.
seriousness of the breach and its impact on the claimant. So one can imagine two circumstances here. Circumstance one is where the local authority accept the main housing duty and do nothing and leave a street homeless person on the street. That's case one. And case two is where they accept the duty, they direct themselves that accommodation has to be within 5 miles radius of the children's school, and the only thing they can offer is 6 miles radius, and they offer that. It's unsuitable. And in my respectful submission, the approach of the court to those two cases ought to be informed by the vastly different facts. So I would submit that the first question that a judge will invariably ask is where on the scale of breaches does this sit? By reference to the claimant. Secondly, why is it that the local authority has been unable to secure accommodation? And linked to that, what is the ability of the local authority to comply with a mandatory order? The Lord Justice Lewis made the point that a mandatory order can have very, very unfortunate draconian consequences, a breach of it. And thirdly, the impact of the court's order on housing applicants. In my respectful submission, there's nothing controversial about those points. They sit comfortably with the case law we've looked at, and they're all common sense, and it would be odd, in my respectful submission, if a different set of criteria applied to housing claims to others that come before the court.
In Khan, Mr Justice Scott Baker made a list. The nature of the accommodation currently occupied.
Yes.
The length of time
Yes.
the applicant had been there.
Yes.
The efforts that had been made by the authority.
Yes.
The likelihood of suitable accommodation becoming available.
Yes.
And then any other particular factors to a judicial discretion. So there were 5 points, and the only one that was somewhat disparaged was resources.
Yes.
A wider resources argument. But
Lord, I didn't dissent from that in the court below. We looked at that as a test. I mean, respectfully, there's a problem with Calm, but it's in a different area. We'll come on to that. But insofar as an exercise of discretion, absolutely, in my respectful submission. But you don't just look at length of time in isolation. Implicit in that is length of time and the impact that's had. Because one can imagine circumstances where a couple of months to somebody who's highly vulnerable is far more damaging than to several years to somebody who can cope with it. So I will come back to our ways, Nali, in the context of the grounds. But the Lords, I think, now have my submissions on the approach to relief.
Are resources something that you can have regard to or not?
Yes.
When you've got it? You can.
Yes, you can.
Right. So you can say, well, I'm not going to go to buy more housing or spend a lot of money on adaptations because my budget is already under pressure.
Yes, you can.
That's acceptable.
You can do that, yes. My respectful submission, Lord Justice Briggs, as he was, acknowledges that in Statutory at para 31. And Baroness Hale acknowledges that in Ali when she looks at the practicalities, got to confront the practicalities of the decision.
But it gets the court into a very difficult area if you have to do that, because the range of activities which a local authority has on which it spends money means there are always discretionary choices. You can give less to libraries or bending the holes in the road. And the implication of saying you can have regard to resources means that to have regard to them in any sensible way means the court has to get involved in those sorts of choices.
Well, it may have to, depends on the nature of the challenge. I mean, I'm not encouraging it, but another way that this claim could have been brought, this claim was brought quite simply as a claim for breach of statutory duty. No evidence in support, as a straightforward claim for statutory duty. I'm not suggesting there are grounds or encouraging it, but it might have been brought as a more nuanced, strategic attack, accepting that Croydon doesn't have the ready stock at its strategic failures, for example, under the Homelessness Act. Then the court would be reviewing an entirely different decision.
But she doesn't need to. She's not worried about the strategy. She wants a house with a toilet next to the bedroom. And the law says she's entitled to one.
Yes.
And you've said she's entitled to one. You've said if
Yeah, absolutely.
That's the problem. I understand you might want to have policies. I understand there are other things you might want to do. But you're up against the hard rock of a law which says if you decide to do it, you must do it.
That's why I made the submission at the outset that the saviour for the local authority at that stage, we're assuming that the duty kicks in immediately. We're assuming that we can't get suitable accommodation even on the hourly short-term basis. What is there to ameliorate that hard-edged duty? And it's the discretionary nature of mandatory relief.
But why should the courts ameliorate what Parliament has decided? That's the first question. Parliament wants you to do it. Why should we say to Parliament, we know you've told them to do this, but don't worry, we won't actually do anything about it?
Well, because, I expect the submission, the court doesn't operate in that way. The court doesn't simply make an order without consideration of the consequences. I go back to my submission.
Anyway, we've gone through it, yes.
The court must look at the broader picture, the effect on others. It's dealing with a finite resource. It's not a perfect world. I open my submissions with that problem of the clash between the duty and resources. That's what these cases are really about. We're trying to find a way that is workable, that protects.
Well, but I'm afraid of, purists would say, put that way, you lose. A duty is a duty, and it's Parliament's job to make sure you have proper resources. If they don't, they better change. They better make it a less onerous duty.
Yeah, that was Lord Justice Ward's solution in, I think it was Airways at that point, and the House of Lords took it in another direction.
Well, they did, but not that they made life easier on suitability. But there will be cases, and this is one, where that route is not available.
Yeah.
So I don't think that really helps.
Well, I want to take this fairly quickly because I'm concerned about time, but part 3 of my submission is about time-specific mandatory orders.
Yes.
I think the quickest way I can deal with this is by simply inviting the Lords to look at the relevant statutory provisions. And this is paras 27 to 36 of my skeleton, where I note that there are 6 reported cases, as far as I'm aware, where the courts have made time-specific mandatory orders requiring a local authority to secure suitable accommodation, ranging from 2 to 6 months. I make the submission that in none of those cases did the court appear to address the lawfulness of that order. Can I just very, very quickly run through the basic statutory provision? I'll take this as quickly as I can. I'm conscious of the time, but it's an important point in my
of course.
case.
No, don't feel under any pressure from us. I mean, the clock says
I don't feel under pressure, but only
yes,
for myself.
no, you're explaining why you're taking it quickly, which is fine. Yeah.
We're now going to go back to the 1985 Housing Act, which is in Bundle 1, Tab 4, beginning, I think, page 25. This is Part 1 and Part 2 are still good law. Part 3 of the 85 Act is now Part 7 of the 96 Act. And Part 2, page 30, Part 2, is entitled Provision of Housing Accommodation. The way I open the submission in my skeleton is that all local authorities are subject to the ultra-vires rule. They can only act within their lawful powers. That is to say, either their specific powers or their general powers. In terms of the allocation or provision of housing accommodation, their specific powers are contained in Part 2 of the 85 Act. And we see Section 9, the court's already been taken to it, gives local authorities very, very wide powers of acquisition, erecting, converting buildings, acquiring houses. And then Section 17 at page 34 gives equally wide powers to acquire land for housing purposes. So Parliament has vested local authorities with a very...
No, give me a second, I haven't got that.
I'm so sorry. Section 17. I've got Section 9, Section 7.
Yeah, I've got it now, thank you, yeah.
They can buy houses, they can lease houses, they can buy land, they can build houses, they can convert, and so on. Very, very broad powers. And then there's a duty, Lordships were taken to it, Section 18, page 37, that they have to then use them for housing accommodation. And then once they've got the accommodation, they can't just dispose of it willy-nilly. They have to do so principally under Section 32, which is page 44. And essentially this gives 4 ways in which the local authority can dispose of housing accommodation held under Part 2. The first is by the right to buy.
So what does dispose mean in this context?
I think it's meant very broadly. It means sell or lease or grant a tenancy on. It must include grant of tenancy.
Yes, I see.
Yep.
I see it include, I mean, we can see from subset
Yep.
3 that it must include.
So it can dispose of Part 2 accommodation under Part 5 of this Act, which is the right to buy, qualifying tenants. It can...
So where are you taking these from?
32 subsection 1,
Yes.
without prejudice to the provisions of Part 5, right to buy.
Yes.
And that provides that a secure tenant who qualifies
I know about the right to buy.
has
Yeah.
a right to a lease or a freehold. So that's one form of disposal. The second, subsection 2, is subject to subsection 3, but subsection 2 with the consent of the Secretary of State. And what the Secretary of State has done is to issue a standing consent for disposals. And then subsection 3 gives us 2 further options. The first is under a secure or introductory tenancy. And the fourth is what would be a secure tenancy, but for paras 2 to 12 of Schedule 1. That is to say, tenancies which are excluded from security, a non-secure tenancy. And then if we go to...
Sorry, hang on 1 second. What was the 4th one?
non-secure. Secure, introductory, category 3. Category 4 is non-secure.
And where do we get that from? I'm sorry to be so slow.
Subsection 3.
The second half of section,
Yeah.
it's the or.
Or any paragraph, yes, or any of paragraph, I'm just about to state my law to it, paragraphs 2 to 12 of Schedule 1.
Yes, yes.
And if I could just go to page 54, we have Schedule 1, and it's entitled Tenancies which are not secure tenancies. So these are exceptions. And if we turn to page 56, at the foot of that page, we have paragraph 4. A tenancy granted in pursuance of any functions under Part 7 is not a secure tenancy unless the local housing authority concerned have notified the tenant that the tenancy is regarded as a secure tenant.
Right, so you can grant a non-secure tenancy to a Part 7 person in the exercise of Section 32.3.
Yeah.
Right. So how does that help us?
Well, what I'm
With the time-limited part.
No, my Lord, if you Lord bear with me, I'll get to the end of the point.
I'm sure. Just before you, your last one. I just. Where were you reading from?
Page 56.
Yes.
Paragraph 4, which is towards the foot of that page.
Oh, right. Sorry. Yes.
Tenancy granted
I find it now. Thank you. Yeah.
And then if we go to page 69, subsection 159 of the 1996 Act, it tells us that the local authority make an allocation for Part 6 purposes.
Sorry. Again, I know you're trying to go quick. 169, did you say?
No, I'm sorry, not 69. We're in the same tab.
All right, 69.
69. I should be watching my Lord, not my papers. I'm sorry.
No. I'm notoriously slow. Okay,
And we've now gone into the 1996 Act.
Yes.
Section 159 is the opening section of Part 6.
Yeah.
And that tells us when a local authority makes an allocation. And it does so where it selects a person to be a secure or introductory tenant. And we've already seen section 166, capital A, subsection 14, that once an allocation can only be made in accordance with Part 6 scheme. So, Lord, drawing the threads together, this is where we're at. The local authority have specific powers, very, very broad powers, to acquire housing accommodation, building, adapting, leasing, whatever. Once they've done that, they can only dispose of it through Section 32, which has 4 ways of disposing. If they want to dispose of it by way of an introductory or secure tenancy, they've got to do that under Part 6.
Yeah. But luckily we aren't doing it because we're doing
No,
non-secure tenancy.
And the 4th way is that they can do it, the non-secure tenancy, under Part 7.
Yeah.
If the local authority, like the London Borough of Croydon, has a Part 7 policy, then it needs to be allocated, use the word loosely, in accordance with that policy.
When you say needs to be, I mean, a policy is only a policy.
Well, a policy gives those to whom it is effect a legitimate expectation that it will be followed.
Yes, all right, but I just want it's different from a legal obligation. And different from Part 6.
My Lord, the submission is simply this. There is a structure. When we look at, for example, Mr Justice Scott Baker, as he was in the Khan case, there was a very general discussion about the local authority buying a property. The local authority can buy the property. And the only point that I make on this part, I'm sorry to labour, it's quite important for my clients, the only point I make is there's a statutory structure. It may end up ultimately with a statutory Part 6 allocation scheme, or it may end up with a Part 7 policy.
Or, no, the Act provides may end up with a Part 7 non-secure tenancy.
Yeah.
You have decided to have a policy which may or may not comply with your lawful obligations, and you haven't shown us which part of the policy stops you giving this tenant. But I assume there's something in the policy, in the Part 7 policy, that sets out the list that you deal with. But I haven't begun to understand, I regret to say, and it's my fault entirely at the end of a long 3 days, I simply can't understand what the problem is. Whether you're saying this contemplates the structure, it doesn't require us to have a policy, and a policy is only a policy, but we do have a policy, and I'm waiting eagerly to know whether that policy says, and because of that, we could never comply with our duty to Mrs.
No, but Lord,
Imam.
Lord, I'm over-egging the pudding, and
Getting
I
to
apologise,
it.
it's my fault. I simply want to make the submission, and I think I have made it now,
Yes,
that there is a structure.
yes.
You can't just go, they don't have carte blanche to go into the market and buy a property. Mr Justice,
Well, they-
and
But they do.
They do have carte blanche to go out and buy a property. They don't have carte blanche what they can then do with it. But that is true. But one of the things they can do with it is the very thing that that it's been said they should do.
Lord, that is my clumsy language. Forgive me. They can't go out into the market and buy a property earmarked for applicant A. Of course they can go into the market and source accommodation.
Why not?
But they can't earmark.
Well,
where's-
why? I don't quite know what you mean by earmark.
Well, in the sense that Mr Justice Stanley Burnton meant, as he was, in the Amir and Begum case. That was the issue in that case. I don't.
Well, we may have to look at it if it's important, and the time will have to take care of itself. But can we just be clear about it? I don't. Well, if you say the answer is to be found in that case, we better look at it. Where is it?
It's bundle 2, tab 33, page 435.
Yes.
And this was a decision in 2002. And it was a most extraordinary case factually. If we could just turn to page 439. And paragraph 1, this was an application by Miriam Begum and her daughter for orders requiring the defendant to provide suitable accommodation for them under Part 7, and then sets out the personal circumstances of the family, including those of the daughter, para 3, age 19, full-time wheelchair user, and then 10 other children.
Yep.
And essentially what this case was about, there was an awful lot of cooperation between the parties in this case, which caused the learned judge to suggest that cases like this may be suitable for some form of ADR. But it was both sides in a sense. The judge records this, accepts the other one's problem, that this was in a family with extraordinary needs, but the local authorities simply didn't have
I
sufficient
absolutely have
accommodation.
that point.
And the practical problem was, or the practical solution was thought to be, para 5, that a pair of adjacent houses at Knapp Road in Bow could be earmarked for these very, very needy and deserving claimants. And so the question of law was whether the local authority could lawfully earmark. And the relevant passage, we'll save time, but the relevant passage is a para 29, which is 445 of the report. And halfway down that paragraph, or nearly halfway down, I am satisfied that only in exceptional circumstances, if at all, may a local authority lawfully earmark a property for a particular applicant on its waiting list before that property is allocated.
So is this talking about Part 6 or Part 7?
That's Part 6, and then we're coming on to
Right,
Part
okay.
7.
Well, that's yes.
It must apply its policy and exercise any residual discretion when it allocates the accommodation in question, not before. There's otherwise a risk that when the accommodation is allocated, there will be someone priority according to the allocation scheme over the person for whom the property has been earmarked. And then a little way down, after reference to Knapp Road properties, a homeless person to whom a duty is owed under 193 or in relation to whom a local authority exercises power, like an applicant on a local authority list, has no right to be allocated any particular accommodation
Yeah.
The duty of the local authority is to provide suitable accommodation, not any particular accommodation. Well, even more so, in my respectful submission, where the local authority is operating a policy, albeit a non-statutory policy, but a policy that strives to create fairness.
But no one
between
is saying,
applicants.
let us suppose that there is a property in West Croydon, which everyone has their eye on, and the decision is made to get it. It would be earmarked for her, just in the same way as if, very unlikely, someone with similar needs, been earmarked because it has these particular characteristics. Someone with exactly the same thing, but even more severe, could at the last minute have it.
Yeah.
Fine, then you have to go and look for another one.
No.
But this isn't a case about earmarking, is it?
Well, my Lord, this isn't the case about earmarking, but it's relevant to my submission. I don't want to spend more time on it than is necessary. It's relevant to my submission. This court, the Court of Appeal, is looking at the test for mandatory relief in housing cases. A number of courts have, without respectfully full consideration of the law, made mandatory orders against local authorities without at least considering the framework that I've sought to lay out and how that order sits within that framework. Of course, a local authority can go out in the market and buy a property, but if it's got an allocation scheme or policy which says that it will distribute or allocate its properties in such a way, even for Part 7 purposes, and public law duties require it to stick to the duty subject to the usual questions of fettering discretion and the rest of it. And that's the basic problem here. Croydon has a policy. It's a policy that purports to allocate amongst Part 7 applicants in a way which is fair. It all goes back to the basic problem. There's not sufficient, I'm not going to repeat it because my Lord's already heard it.
No, but I think this is quite important. So, yes, and this is, I think, what I always thought your case was, not that there is, as such, some specific provision you can point to in the policy, which means that even if they bought a property, it couldn't be allocated, using that word in the non-technical sense.
Yeah, Lord, yes.
You're saying that once you have done that, de facto, to meet a particular problem, you're being unfair to everyone else because everyone else has a particular problem.
Yes.
And why should you go out into the market and buy a house for this single person who is no doubt very deserving, but almost by definition not the most deserving person waiting for on the Part 7 waiting list? That's your point.
That's the point. Yeah.
To which Mr Westgate's answer is that's not the court's problem.
Well, the court has
the others may have claims, in which case they will bring them.
The court has to act in the real world, in my respectful submission. It has to be aware of the effect of its orders. We talked, Mr Westgate and Ms Steinhardt refer to the rule of law in their skeleton. And in my respectful submission, a court which orders a local authority to provide, within a period of weeks or months or whatever, accommodation to someone who is 15th in the list, if anything, is likely to undermine the rule of law because people simply won't see the fairness and the sense of that.
What you should be doing, you see, is buying enough accommodation or using Part 6, because this doesn't affect Part 6 at all. You should be using all of that to clear the backlog on Part 7, and you should be jolly careful about how you decide what is and isn't suitable.
And then we have to explain that to the many thousands of people who are on the Part 6 register, some with the most
And you
serious...
say blame Parliament.
But this doesn't help you with Part 6. It's only Part 7, really, isn't it?
Yeah.
You mentioned that there have been 6 cases where mandatory orders have been made.
Yes.
And you said that in none of these cases did the courts consider the sort of argument that has been that we've been addressed with. But what's the product of all that? Are you saying, well, these are orders that of a kind that should not have been made? That these orders shouldn't have been made, or is it just a historical observation?
It's a historical observation. I make it very clear in my skeleton, my lord, that I'm not suggesting that those cases were wrongly decided on the facts. I'm not inviting this court to overturn any of those cases. And my lord, two of those cases, the Tamage and Batanchi, weren't decided under this Act at all. They were decided under the National Assistance Act 1948, which has nothing like, Lord Justice Lewis would know this, nothing like the constraints in terms of allocation and whatever. It was an act which imposed obligations on social services authorities, which originally had the responsibility for homeless persons. So those acts, and that's a danger, because some of the cases rely on the National Assistance Act cases without realising that there's a different statute.
All right, but then you're beginning to say that they were wrongly decided because
No, they might be right on the facts.
Yes, I see.
The trouble is, the problem with most of these cases, which is why I made the point at the outset, so often the local authorities living in denial.
Could I then just supplement my question by saying, could you give an instance of a case in which a mandatory injunction might be appropriate under Part 7?
This is the case.
Sorry?
I'm sorry.
Yes, I mean, is the product of your submission about the structure to say that a local authority that has policies and has tried to think it through and so forth, it's hard to consider a situation in which a mandatory order might ever be appropriate? Is that
No, I'm not suggesting a mandatory order would never be made. Of course not.
Well, but both of you, I think, this just shows how difficult this area is. It's slightly victims of your own submissions of principle. If it's unfair to buy a property for one person, and it doesn't actually have to be a buyer property, we don't know in those other 12 cases how they, either 6 cases or 4 cases, how they did solve the problem. But it may well have been to buy a property. But if not, it was to find a property somewhere else. The effect of the court order is to promote someone above the position they would have been in according to the court's policy, thereby creating what you say is inherently wrong, a public law unfairness.
Yes.
So isn't the logic of your position that those other 6 cases or 4 cases were in fact wrongly decided?
Lord, I simply don't know the answer to that because
Well, that's very frank and understandable.
Because the courts didn't consider it.
It may have been.
And didn't look.
May have been wrongly decided.
May have been wrongly decided, my lord. But I make it clear in my skeleton argument. I'm flagging up the problem. I want this court to understand the structure and the difficulty. I'm not saying that a court cannot make a mandatory order. Absolutely not my submission. It just needs to be aware of the powers of the local authority and how it works.
No, okay. Can I just ask one other question before we leave this point? This has been introduced under the heading of time-limited orders.
Yes.
It seems an odd label. It's not really about them being time-limited. It's about mandatory orders, full stop, isn't it? Or which always will be time.
Time-limited mandate. It's my crude way of referring to a 12-week order or a 6-week order.
Yeah, well, but a mandatory order will always, it would be defective if it didn't say when it had to be complied with by. So they will always be time-limited. I'm not being picky, I'm just trying to understand.
No, well, obviously your lordship's right.
Yeah, okay, no, that's fine, good.
Yeah, it's just that I think actually it goes back to Tamage, because in Tamage, the court set 2 periods, one period for identifying a property and discussion with the plaintiff in those days, and then another period to actually do the administrative action to put it into place. So that's why I use that language. I apologise.
No, I've got...
I think we're on the same page. And I don't think it's been put against me that the local authority, could you go into its general powers local authorities have two powers, specific and general. The Deputy Judge deals with this, and the Lords will know that there is a broad general power under the Localism Act 2011, but that's subject to boundaries. One boundary is...
I think Mr Westgate took us to some, at least, of the assembly provisions. So implicitly, he was saying these are the powers that were to be used. Yeah. Okay.
So I think it was raised in the court below. So, that wouldn't be an answer.
No, okay.
Either. So we do respectfully invite the court to give consideration to that question. And
Very well. Now, you're the best judge of your time, but you've got to leave some time for Mr Westgate.
can I go to the judgment briefly?
Yes, well, I think that is really quite important.
I have to check the time because I think that clock's losing even on yesterday. So,
Well, just one moment. You've already got to go at 4:30 real time. The duty is 4:25 this time. Yeah, we have no leeway to go beyond 4:30 real time, which is 4:25 on that clock. Mr Westgate may have to have very limited time to reply, and if really necessary, though I don't like this, we may have to allow him to add 1 or 2 points in writing. But if you can be done in the next 20 minutes, you can have a quarter of an hour. Is that realistic?
I'll do my very best, my Lord, yes.
Okay.
Thank you.
Perhaps he may not need a quarter of an hour.
This is your fourth point, submissions on single ground of
Fourth
appeal.
point, my Lord, yes. Now addressing point, part 4. Can I just, I'm not going to take, I don't have time to take the court to it, but I put in ex parte waters on this rule of law point, which is at B1, tab 25.
And what does it say in a sentence?
Simply because it's not the function of the administrative court to grant relief to vindicate a breach of the law. It was quite a serious case. It was a breach of the consultation duty in the demolition of a large housing estate in North London. It had been flawed, and
Okay.
counsel for the tenant said, it's your duty to grant a relief. And Lord Justice Judge, as he was, says, no, that's not the way that judicial review works. It's subject to an overriding discretion.
Right.
And we can look at the benefits and disbenefits of the action. I simply put it in on that.
No, thank you.
Can I get then to part 4 on the judgment? The Lords obviously have looked closely at the judge. A very careful and full judgment. It deals with 3 issues, one of which, can I say, the second issue was an Equality Act issue where there were challenges to the spending and the resource allocation of the local authority. And it was said, for example, that a reasonable adjustment would be to employ more staff and obtain more properties. That was unsuccessful, and that was backed up with the damages claim. That was unsuccessful. But if we look at page 41, para 23, the Deputy Judge sets out the 3 grounds. On ground 1, the only issue was discretion. And then the discussion on ground 1 begins at para 54. At 55 records a very sensible concession by Ms Steinhardt that whether to grant a mandatory orders relief in relation to the defendant's breach was a matter of discretion. Then sets out the submissions, and then at 65 poses the question, should a mandatory order be made? And then considers relevant authorities, all of which are close friends to us now in these proceedings. And then the substance of the decision is at 81, which consists of 8 sub-paragraphs, and it's followed by 82, where the deputy judge carries out the balancing exercise. It's, in my respectful submission, a model exercise of judicial discretion. But nonetheless, it's said that it's wrong. So I'm going to address now my friend's criticisms of this, and I think his main criticism is levelled against Roman 1 at page 66, 81.1. And this is where the judge, deputy judge, looks at 2 points, but they're related points for reasons that I've already submitted. He's looking at the seriousness of the breach, and he's looking at the impact of that on the claimant. And although he leaves it firmly with me and doesn't adopt it, he doesn't dissent from the submission that the accommodation was overall 9/10 suitable. And that's because Mr Beasley, in his very comprehensive evidence, set out all the reasons why this was good accommodation for the appellant. But consistently with...
It's twofold. One, the judge was wrong to say something like the test was intolerable or enough is enough, and 2, was wrong to require you to require the claimant to put in evidence. Those are the 2 criticisms.
Yeah.
And what's the answer to them?
The answer is that we need to go to Arley in the House of Lords. Yet again. Now, I want to make it quite clear that whereas mandatory relief was one of the certified issues in the House of Lords, for reasons that Baroness Hale set out in Borough 56.
Yes, Mr Westgate.
I'm so sorry, 64. It didn't, in fact, fall for decision.
Yeah.
But that doesn't mean that it's not alluded to in other passages. So, in my respect, I can take this very quickly because the court is very familiar with this. But if we look at paragraph 4 of Lord Hope, we know now that what was going on in this case, it was about the lawfulness of Birmingham's homeless at home policy and whether you can reconcile the 2 problems. I want to deal with it. I know I will do it as quickly as I can, but I do need to deal with this. Is it irrational to have a policy which treats accommodation as both unreasonable for 175 purposes, but reasonable for 206 purposes? Suitable for 206 purposes. Court of Appeal said no, you can't. Mr Justice Warrington, you can't. House of Lords says yes, you can if you give it a temporary policy. So the decision is looking very much at how far can you go into the suitability time span before it stops being suitable. And that's what Lord Hope is looking at 4. And the only sense that you can make of that, in my respectful submission, where His Lordship refers to the court stepping in, is stepping in to make some order. The court has no business to step in otherwise. He's referring specifically in the context of Lord Justice Alden Cordona, the court will not make an order to force the local authority to do it. That's a reference to mandamus or mandatory order. On the other hand, it may feel that it is proper for it to step in, i.e. step in and make a mandatory order, where the time that is allowed to elapse becomes intolerable. Now, I accept that the House of Lords did not deal in terms with issue 3, the mandatory relief criteria, because they didn't need to, because most of the families have been housed. But nonetheless, there's no other proper reading to that, in my respectful submission, than looking at the circumstances in which a court will step in to make a mandatory order. And likewise, because that's prefaced with a reference to Baroness Hale's reference to the practicalities of the situation. So that takes us to paragraph 50. And that's where the discussion begins, and Her Ladyship brings in resources. The same thing, again, at what point will the court step in? The situation is particularly about, and so that the House of Lords is saying, it's all right, you can have this homeless at home policy, Birmingham City Council, but only up to a point. But be careful, because you might get to a point where the court will step in and make a mandatory order. Now, with those submissions in mind, can we look very closely, this is important to do so, at para 81, what the judge actually said, a deputy judge actually said. And if we go back, this is 81 of the judgment, page 66 of the core bundle. And after referring to the 9/10 suitable submission, he says, I do accept that on the evidence before me, the claimant has not established that the conditions in which she is presently living are having an extremely serious effect on her, or that the situation is intolerable, or enough is enough. So first and foremost, the test he's actually applying is extremely serious effect. Well, query, would the court contemplate a mandatory order if it was only a small, trivial effect? So that we need to be fair, respectively, to the deputy judge, the words he chose. And then he says, rightly in my submission, I need to understand, I need to inform myself as to what effect it has had. So where can I find that? What's the evidence? And he said, there's over the page, there is simply no evidence about the present effects on the claimant's day-to-day life. The assertion, the problem with the level access was put forward in 2015. This was 2020, since when the appellant's partner had moved in. There was simply no evidence. And that's all the judge is saying. So he's saying, well, is there an extremely serious effect on her? Or has it become intolerable, or enough is enough? Citing, incidentally, Mr Justice Lyndon in M, who applied the same test, and saying, well, I can't inform myself because of the lack of evidence. And it's extraordinary. Every case we've looked at, I'm not going to give all the references now, every case we've looked at, there's been evidence, medical evidence, evidence of the current impact. Why wouldn't a claimant come to the court and say, look, you've got to make an order, these are my circumstances? And if I may respectfully say so, I don't think I've ever had a judicial review case with no witness statement supporting a claim form. It's extraordinary. Now, it may be that that's because it was thought it was a straightforward case for breach of statutory duty. But that was the problem that confronted the deputy judge.
Right, we have that point.
So, my Lord, that in a nutshell is my submission on that. Go to 81. I mean, obviously, my Lord will anticipate my submission that the thing's got to be read as a whole. But 81 Roman 2 is where the deputy judge quite properly then says, okay, well, Croydon, what have you shown me to demonstrate that you're unable to meet your duty? Quite properly looking at Croydon to do that, and Croydon meet that challenge. They put in a very long, comprehensive...
What is he saying here, actually, rather than commenting on how good it is? When he says Mr Beasley's been considered for all available properties across all potential pools of accommodation available, is that, as a matter of fact, a statement that they've looked at all the properties currently in their Part 7 pool and all the properties in their current Part 6 pool. What is it actually saying?
With respect, that's not a fair representation of Mr Beasley's evidence.
That's what I'm asking. What is the position? As a matter of fact.
Oh, well,
What does it mean, this sentence?
sorry, which sentence?
The claimant is, according to Mr Beasley, be considered for all available properties across all potential pools of accommodation available to the defendant, and no property has been excluded. And I simply want to understand, as a matter of fact, does that mean all properties that were in the Part 7 pool and all properties that were in the Part 6 pool, or does it mean something else?
It does, doesn't it? Can I just...
Yeah.
Yeah, available, although not every property in the pool.
But
I'm sorry,
available,
not
all that
every
means
property
is
type.
everyone that comes up.
Everyone that comes up.
It's everything that comes up in the Part 6 and the Part 7.
And Part 7.
It's both.
Yeah.
Right. So
He does give evidence that they,
yeah, there's any vacant property in Part 6 or 7.
yeah. And the evidence is that he also looked into the private rented sector.
Yes, but you're making what is evidence of. You're not dealing with Mr Westgate's criticisms of that evidence, but perhaps you're about to. For example, he says he says he looked into the private sector, but he didn't actually, because he said they'd all be too expensive, so there's no point looking at detail.
But the point he makes, I might struggle to turn up the paragraph number immediately, but the point he makes, my lord, is we're here dealing with a very special form of accommodation, adapted or adaptable accommodation. And he makes the very fair point that it's particularly difficult to source that type of accommodation in the private sector.
Is it? I mean, you need a 3-bedroom vacant property with enough room for a lift.
Well,
And it might be they won't come up every day, but in the whole of Croydon, I'd have thought there would be a lot. So
no, but all,
especially
with
if you look
respect,
beyond. And then you've got to spend money.
they would have to spend money. They would have to have the landlord's consent to the
Unless they bought it.
And they may need planning permission and things like that. The landlord, and this is the evidence, Mr Beasley, paraphrasing it, may be reluctant or typically reluctant to give permission for that type of alteration for a property that is to be put on the letting market. I don't accept the criticism of Mr Beasley as an expert. He gives his credentials, he's got many years' experience in the field, and he is saying that he has looked into the private sector. There are problems with affordability. They've got to balance the books at the end of the day. There are problems with landlords, understandably, not wanting their properties adapted. And the pool is limited. But the Deputy Judge accepts, halfway down, accepts Mr Beasley's evidence that the defendant is doing what he reasonably can, consistent with the proper application of policies and limited resources to fulfil the statutory duty.
Yeah. I'm just trying to understand the factors. I'm not making a comment on them, whether they're good or bad. I'm trying to understand it. On this aspect of the case, when we're talking about properties, looking at 81.2 and 81.7, the impression I'm forming is that when we talk about all reasonable steps in relation to this simple matter of properties alone, they've looked at all vacant properties in Part 6 and 7. They haven't looked outside because they think, for the reasons you've given, they're unlikely to find a solution outside. And then the last question I want to check is that they weren't going to change the priority of allocation for the properties on Part 7. It would go to the person who'd been on the Part 7 list longest. What about the Part 6? Do they not take things from Part 6 to Part 7 at all? Or do they take them and give it to the top of the Part 7 list?
I don't want to give the wrong answer to that. Perhaps
Well,
So we need to know what they've done.
I'm afraid it's not, I'm afraid, to ask representative of your client behind, but to point to us what is said in Mr Beasley's evidence.
Yes.
Yeah.
That's what we need to know, is what steps he took, and then we can decide whether
Or rather,
they were
more
reasonable.
accurately, if I may say so, what steps he says he took.
Your Lordship, your Lordships would have seen that the Deputy Judge did summarise Mr Beasley's
Mr Beasley
evidence.
at paragraph 86.
Paragraph 22.
If this is relevant, Beasley at page verse 40 of the supplementary bill, paragraph 86, say we've been actively considering the claim of both temporary and permanent accommodation under both the Part 6 and Part 7 schemes. I don't know whether that is any way, and they've been doing it since 2015.
But would he give a Part... Does he say whether or not they would give a Part 6 to a Part 7? He's not going to give a Part 7 to anybody other than the next person on the Part 7 list. But does he say anywhere that we looked at Part 6 properties, and if there'd been one that had come up which had 3 rooms and a wheelchair lift, we might have given that to them? Or does he say, no, that wouldn't be fair to the people on Part 6? Then we can decide whether that's reasonable or not, but we need to understand what he says they're doing.
Well, Lord, I can't immediately put my finger on it, and I don't want to give
Wrong answer,
information on
sir.
that. I'm sorry, my Lord, it's late in the day, and
Yeah.
No, fair enough.
I
But
can see that maybe.
no, well, let's let you make the rest of your points.
Yeah.
We can ultimately read the evidence for ourselves.
Yes, I'm helpfully reminded of paragraph 86, Mr. Beasley's evidence. Can I just leave the reference?
And we've got it.
You can read
Well,
it.
this is what my Lord just took you to, isn't it?
Yes, that's what. Lord, I'm concerned about time.
Yeah. Okay, well, we can read the evidence, but yeah. I think you were saying there were 3 main criticisms. One about having applied the wrong test in 86.1, 82.1. Secondly, about
About
so you actually tell us
relying
the
on
3
the,
words.
expecting the claimant to put evidence forward.
Yeah.
Yeah, well,
What's the third one?
The answer to the response to the first criticism and wrong test, your lordships have that. Firstly, it's not a misreading of Ali.
Yeah,
And
as you say, I've written it down. Yes. Yep.
Yes. And secondly, and in fact, that wasn't the first test he applied. But one needs to look at that in context. He's simply saying, I need to understand the impact this is having.
Yes.
I mean, Lord,
You made that submission. Yes, that's exactly what I've noted. Yeah.
Mr Westgate said that there's no evidence of proactively searching for properties. Where there is, and Mr Beasley sets out a number of steps that they're taking proactively. They include the Home Finder UK, which is, I'll just give the references. That's para 43, sorry, para 102, page 43, Home Finder UK properties. The property company that Croydon Council set up, Croydon Affordable Homes, that's para 94 of his evidence, page 41. The active search in the private sector, that's para 90, page 41. And the extraordinarily high nomination rights secured under the planning legislation that Lord Justice Lewis referred to, is para 88, page 40. So it's not right to say that Croydon Council is not proactively searching for properties. It's doing what it can. Mr Westgate made the submission, which took us a little bit by surprise, that the local authority hasn't considered an out-of-borough placement. I don't recall this being raised in the court below, but can I respond to it briefly? Section 208 of the Housing Act 1996 says, so far as is reasonably practicable, accommodation should be secured in borough. And the Nazella Meso case that your lordships referred to in the Supreme Court was all about out-of-borough placements,
Yes.
which are prevalent.
Which are what, sorry? I didn't hear the word.
I'm sorry, I said prevalent.
I still didn't hear.
Yes.
Prevalent.
Prevalent. Right, thank you.
And also, it's not what the appellant has asked Croydon to do. It's recorded, supplementary bundle page 10, for example, on the housing assessment, that she would like accommodation within easy distance of the children's schooling links, and that she would like to stay in this property if possible.
Could you just give the page reference? Page reference again?
I'm so sorry, my Lord. SB 10
Thank you.
and SB 11 is the OT's report, where it says that Mrs Imam would like to stay in this property. She liked the area, it was close to the shops.
Okay,
and
we
her
don't need to
elder
read it.
children's
You've
school.
got very limited time. You've got the references. Yeah.
Can I just see what I need to do?
Yes, of
with?
course. Please do. Please do.
Lord, I think, one way or another, although with some brevity, but my lords do have my skeleton.
We do
They will
indeed.
look at that.
No. Thank you very much. I'm sorry you've had to it's tricky to judge what to put the emphasis on, but we have all your points. Thank you very much.
Yes. I mean, Lord, my headline submission, as I said, that the judge had the discretion, and there are a number of points that he took in favour of the
Yes.
appellant.
I have that point.
And he directed himself that this is a long period of time and the starting position. But nonetheless, as a matter of judicial discretion, he came to the conclusion that it was not the right case to make a mandatory order.
Thank you. Yes, Mr. Weston.
Well, yes, can I deal first of all with a few points about the observations that have been made? About
Yes, we have an absolute. You have 8 minutes.
Yes, well, I'm going to start
Right. Okay.
with the point about the judgment.
Yep.
Because that's what the appeal is, after all, about. If I can deal with the last set of points about what have been done and proactive searches. Starting with the out-of-borough placement point, you have my submissions about that.
Yes, we do.
Opening, but the point you've raised against us, well, the point seems to be made that it's not reasonable to require anything to be done there because of comments that were made in Noti's report some 8 years ago.
No, in her application and assessment, the disability application, when she told the disability assessor she'd like to stay where she is because the children go to a local school.
No, indeed, and of course she likes the area, but it's the point about this case is the suitability of the accommodation for reasons that have been assessed, and to say that because she has a preference for that area, that therefore makes it unreasonable, to use Mr Rutledge's formulation, it's unreasonable then to look outside the borough. It ignores the fact that it's the obligation on the authority to satisfy the duty. I won't press that any further. So far as the other points, home finder, affordable homes and nomination rights, none of those really deal with the applicant's circumstances, they're generic points. And so far as the private rented sector is concerned, you already have the point that there is no evidence at all as to what was actually done. And the point on the private rented sector is perhaps a good example, because the points made by Mr Beasley were to the effect, well, we can't look into this because it's too expensive, because landlords don't like to have adaptations and so on. Again, they're broad generalities of the kind that...
Well, these are really points you made before.
No, indeed. Well, in which case, but coming on to stepping in, the test in subparagraph 1 of 81, you have my submissions on the threshold in Ali not being the law. If the judge did apply it, he misdirected himself. And we suggest that the judge clearly did misdirect, clearly did apply that, because he not only said in 81.1, at the passage cited to you by Mr Rutledge, that the appellant had not shown that the condition she's living in are presently having an extremely serious effect on her or intolerable. But he goes on at the end of that paragraph to say that she hasn't established that her present situation is at the level discussed in the speeches of the members of the appellate committee. And so he clearly is applying that as a threshold that she has to establish in order to get relief. Or at least he is pitching the kind of evidence that he needs to look at on this issue at that level. And if, as Mr Rutledge says, that the test is whether the conditions are having an extremely serious effect on her, that in effect is treated by the judge as being the same test. But in any event, even if it's not, that's an error of law too. And we have that in our grounds, point 1c, and that too adds something to the test, which it's an error of law for the same reason. So far as the Ali interpretation point goes, the submissions made read, we suggest, far too much into the wording of stepping in. That's a way that the exercise of the supervisory jurisdiction is often described in the same way as one talks about the court intervening or interfering. It's a metaphor, but it doesn't imply that you make a particular order, still less that there's a test for a particular order, still less that there is a test for a particular
Stepping
order.
in then just mean hearing a judicial review claim.
Well, it means dealing with the issue about, it means dealing with a public law issue. Now, of course, once you've dealt with it, if you make a finding in favour of the appellant or the applicant, then normally some relief would follow. But what it doesn't imply at all is that that's a test for the circumstances in which you do make a particular type of order. Still less in a case like this, where the implication is that the test is some additional intolerability in addition to the intolerability that you find in order to establish the breach in the first place, which we respectfully suggest just doesn't make sense. So the can I then come on to deal with the earmarking point, which in the end came down to a point to the effect that the authority cannot allocate in breach of their Part 7 policy, not that any point of the Part 7 policy was relied on. With respect, this just isn't a point of law. It may be that it's a factor that goes to discretion. You have my submissions on that. But what it can't be used for is a basis of saying that the court ought not to make a mandatory order or any kind of order because there's some kind of legal impediment that arises because of the Part 7 policy.
No, but it's the way it'll have to be put is that it's reasonable for the authority not to buy, in this case, 15 properties because that's the only way.
No, indeed, but so put, that's an argument about fairness.
But reasonableness, not about legality.
Yes.
And you're saying the judge treated it as a matter of absolute law?
Yeah, well, he certainly at 62 he did. I accept that it later on he put it on a broader basis, but that was wrong for the reasons we suggest. While dealing with that, Mr Rutledge referred to Walters. I'd ask you to look at page 362. It's clear that's a case where the court thought that was a trivial breach. And if I can look at the yes, Mr Rutledge relied very strongly on Hendy as being something which sets the standard, as he put it, for mandatory orders. With respect, that simply doesn't justify the foundational status that he accords to it. It's an authority which is on a different statute, and it's not right to say that Lord Justice Scarman's judgment represents the majority decision in that case. It was an extemporary judgment, where Lord Denning gives the first judgment saying there's no breach. Lord Justice Stamp then says no mandatory order, but he agrees with Lord Denning. He says it for the same reason as Lord Denning. And therefore, if he's referring to relief in that context, what he appears to say is it's a kind of case where the authority is getting on with fulfilment.
It's obiter in any event.
And it's obiter in any event, and Lord Justice Scarman is in the minority, and the probanda that he comes up with simply don't match the tests that have been set out in subsequent cases that we went through.
Well, no doubt.
I'm going to stop.
Mr. Westgate, you took your points in order, and I'm afraid that's your last one.
Yes.
Thank you very much. Mr. Nabby, do you have some materials for us?
My lord, yes I do. So, what we have, and I think...
We are very short, so just give them to us.
Yes, I'll just
Don't spend time explaining.
Very well.
If you give them to the associate.
Sorry?
Yeah, do they also exist in soft copy form? Well, the note obviously does.
I think we received an email, didn't we, which contains the note.
What you have is notes, 5 sets of notes on section 69, one note with statutory provision behind them, and then you have two lever arch files containing the same materials, notes explaining, hard copy notes for each of you explaining what's in those two lever arch files, and then emailed versions of all of those.
Thank you.
Thank you. Well, I think we are not going... If you give it to the associate after we rise, because one of us has to be somewhere else very shortly, would you just put them up on the bench and the clerks will pick them up later? Associate, you put them on the bench and the clerks will pick them up later. I won't give you the usual formula about we will of course be reserving our decision. You know the principles that apply. And thank you for some very succinct and cogent arguments on a very difficult area.
Well,